Independent medical examinations. What are they? When should you do them? And how should you do them? I think the first thing that you need to keep in mind is that IMEs are something that are integral to any part of a claim. If you don't have an IME, you probably are going to have major problems in winning the claim. If you write a bad referral letter, you're also going to get a bad report. So today what I'd like to do is talk about what you need to do to decide when an IME is necessary and what you need to do to write a good referral letter. What do you consider when you're looking at an IME? What do you want to do? What are the advantages and what are the disadvantages? Well, some of the disadvantages are they are costly. An IME can cost anywhere between $250 and $1,000. You also get a negative report, and as the little picture shows, I hate to admit it, but I've shot myself in my foot several times on these, so you need to be very careful. And third, you can have a very upset employee. And if you have an upset employee, you may have a labor problem, an employment problem, and these are things that you have to consider. However, I think the pros more often than not outweigh the cons. First, in my experience, 90% of the claims are decided on medical issues. The reality of it is, if you don't have a medical report that supports what you're saying, you most likely are going to lose. Second, you're going to at least establish a baseline. Even if the report supports the allowance of the claim or a new condition or whatever the issue may be, you are going to have a baseline that you can use for future issues. I often suggest in these types of situations that in addition to addressing simply the allowance or the additional condition that may be at issue, to also address things like max medical improvement and future treatment. These things can always be helpful, especially when other things develop in the claim. Third is if the claimant does not appear for the examination, doesn't comply with the rules, you have the ability to suspend a claim. This can be very important because if the claim is suspended, benefits are not paid and other actions are not processed in the claim. So this is something that you really need to consider in all these cases. Last year I was looking at some of our internal statistics and I set up about 175 of these myself and wrote the referral letters. So it's something that is done a lot, but it needs to be done well because as I said before, if you don't do it well, you're going to have a lot of other problems. The bottom line on all this is you have to do a cost benefit analysis to determine what is the best course of action. Usually the best course of action is to set up an IME. Some of you may be asking yourselves, well, what's the difference between an IME and a file review? What's better? Well, and I think most of the cases, I believe an examination is always superior. Why is that? Well, the major reason is when you have a doctor talk to the claimant, he or she is going to obtain a history from the claimant as to what they believe is the cause of their problem, what their medical history is, and all those types of things. A file review is simply a review of what you have. I think the best thing to do in these cases is to always have an examination when you can. Now, some situations may not make sense, and obviously you can't do it in the death claims and things like that. But I believe an examination over a file review is always the best course of action. How and when do you schedule an IME? And as the cat tells you on the clock there are time frames. And in the workers' compensation world, if we don't meet time frames, we got big problems. So, what is your time frame? Well, we're calling it the 45-day rule, but the commission several years ago when we decided to speed up this process put a rule in place that said employer has 45 days from the date a claim is filed to request medical releases, obtain medical records, schedule an IME, and file the report with the commission. Well, as those of you that are in the system know, this is not much time. You have to move. So in these kinds of situations, I would suggest that you remember that time is of the essence. Sometimes you may wish to actually start the processing of the claim, or if you're referring it to a lawyer or a service that's scheduling examinations, before the actual claim application is filed, because your time is short. Another very important fact to remember is if you schedule your examination within the 45 days, more often than not, the Industrial Commission will grant a request for continuance if you schedule the examination. The problem that comes up, and it comes up frequently because of the timing here, someone files a claim and the claim is not sent in by the employer, it's not processed, or whatever it may be, but by the time it gets to the person who scheduled the examination, you have a situation where it can't be done within 45 days. So in these scenarios, it's imperative that you schedule the examination quickly. Good afternoon, everyone. Thank you for attending the IME webinar to address when and where you should do an IME. First, if you're having any technical difficulties, you can email Kay Ramirez at bugbeelawyers.com, and she will hopefully correct whatever problem you may have, or you may call her at 419-244-6788. Once again, that's Kay Ramirez at bugbeelawyers.com. And I'd like to thank Carrie for doing all the IT and marketing portions of this presentation for us. Independent medical examinations. What are they? When should you do them? And how should you do them? I think the first thing that you need to keep in mind is that IMEs are something that are integral to any part of a claim. If you don't have an IME, you probably are going to have major problems in winning the claim. If you write a bad referral letter, you're also going to get a bad report. So today what I'd like to do is talk about what you need to do to decide when an IME is necessary and what you need to do to write a good referral letter. What do you consider when you're looking at an IME? What do you want to do? What are the advantages and what are the disadvantages? Well, some of the disadvantages are they are costly. An IME can cost anywhere between $250 and $1,000. You also get a negative report, and as the little picture shows, I hate to admit it, but I've shot myself in my foot several times on these, so you need to be very careful. And third, you can have a very upset employee. And if you have an upset employee, you may have a labor problem, an employment problem, and these are things that you have to consider. However, I think the pros more often than not outweigh the cons. First, in my experience, 90% of the claims are decided on medical issues. The reality of it is, if you don't have a medical report that supports what you're saying, you most likely are going to lose. Second, you're going to at least establish a baseline. Even if the report supports the allowance of the claim or a new condition or whatever the issue may be, you are going to have a baseline that you can use for future issues. I often suggest in these types of situations that in addition to addressing simply the allowance or the additional condition that may be at issue, to also address things like max medical improvement and future treatment. These things can always be helpful, especially when other things develop in the claim. Third is if the claimant does not appear for the examination, doesn't comply with the rules, you have the ability to suspend a claim. This can be very important because if the claim is suspended, benefits are not paid, and other actions are not processed in the claim. So this is something that you really need to consider in all these cases. Last year, I was looking at some of our internal statistics, and I set up about 175 of these myself and wrote the referral letters. So it's something that is done a lot, but it needs to be done well. Because as I said before, if you don't do it well, you're going to have a lot of other problems. The bottom line on all this is you have to do a cost-benefit analysis to determine what is the best course of action. Usually the best course of action is to set up an IME. Some of you may be asking yourselves, well, what's the difference between an IME and a file review? What's better? Well, in I think most of the cases, I believe an examination is always superior. Why is that? Well, the major reason is when you have a doctor talk to the claimant, he or she is going to obtain a history from the claimant as to what they believe is the cause of their problem, what their medical history is, and all those types of things. A file review is simply a review of what you have. I think the best thing to do in these cases is to always have an examination when you can. Now, some situations may not make sense, and obviously you can't do it in the death claims and things like that. But I believe an examination over a file review is always the best course of action. How and when do you schedule an IME? And as the cat tells you on the clock there are time frames. And in the workers' compensation world, if we don't meet time frames, we got big problems. So, what is your time frame? Well, we're calling it the 45-day rule, but the commission several years ago, when we decided to speed up this process, put a rule in place that said employer has 45 days from the date a claim is filed to request medical releases, obtain medical records, schedule an IME, and file the report with the commission. Well, as those of you that are in the system know, this is not much time. You have to move. So in these kinds of situations, I would suggest that you remember that time is of the essence. Sometimes you may wish to actually start the processing of the claim, or if you're referring it to a lawyer or a service that's scheduling examinations, before the actual claim application is filed, because your time is short. Another very important fact to remember is if you schedule your examination within the 45 days, more often than not, the Industrial Commission will grant a request for continuance if you schedule the examination. The problem that comes up, and it comes up frequently because of the timing here, someone files a claim and the claim is not sent in by the employer, it's not processed, or whatever it may be, but by the time it gets to the person doing the examination, you have a situation where it can't be done within 45 days. So, in these scenarios, it's imperative that you schedule the examination quickly. Well, let's talk about the legal requirements for an IME. What do you have to do? What's the commission told us, and how do you do it? Well, first, you have to give notice of the examination to the claimant or his counsel. In some situations, you can give it to both, and that's probably the best case. We have several firms that we deal with on a frequent basis, and we will send the letter not only to the lawyer, but also to the claimant. And I think that's the best course of action if the law firm has authorized that. You also must provide a list of the questions that you've asked the doctor and the medical records you've supplied. A question that often arises is, do you have to send the other lawyer or the claimant your actual referral letter? And the answer is emphatically no, you do not. What the rules require are that the questions and the medical records be supplied. Now, as we'll talk about in a little bit, your letters should be rather antiseptic, so it's not a big issue. But sometimes people write referral letters that have information in them that you really don't want out into the public domain or in the workers' compensation file. We also supply the list of questions and the medical reports to the Industrial Commission in every situation. So those are things that you got to make sure that you do each time. Generally, the original report needs to be provided to the claimant, or if he's represented or she's represented, to their counsel. And as I said before, you need to submit a copy of this report to the Industrial Commission and to the injured workers representative as soon as you have it. What about supplemental reports? Supplemental reports are interesting. If you have a supplemental report, you do not necessarily need to submit that because it's not a new examination. Oftentimes, you may ask the doctor for a supplemental opinion on a treatment issue or an additional condition or something along those lines. And if the report is not favorable, you are not bound to submit that to the commission. You may wish to do that anyway, but you are not required to stop or to submit that if you choose not to. What are the essentials of a good referral letter? And as I said before, I think the most important thing you do in any claim is the referral letter. This needs to be done well. It needs to be detailed. It needs to have a lot of information in it. So let's talk about some of these things. Now, it seems like common sense, but you need to identify the issue for the doctor. Why is he examining the claimant? Is it an issue of an additional condition? Is it an issue of extended disability? Is it initial allowance? Is it a referral for vocational rehabilitation? What is it? And I can't tell you how many letters I've seen over the years that just say, hey, doc, what do you think? They don't ask the specific issue of the doctor. You need to tell the doctor what the claim's been allowed for and disallowed for, because that's critical. As many of you know, we have a lot of claims involving back issues and other things along that line, and it may be allowed for a strain and disallowed for a herniated disc, or disallowed for a disc at different levels. All those things are critical because you want the doctor to make a specific conclusion with regard to a specific question you ask. Tell them the date of injury or the type of injury that's being alleged. Did it occur on a specific date? Is it a wear and tear injury? Or are they alleging a flow-through type of injury? These are things that the doctor needs to know and need to be part of your referral letter. What's the mechanism of injury? You must be precise. Now, in this area, I think that, as the old saying is, a picture is worth more than 1,000 words are important. If you can have a video of the job or pictures of the job, that's very helpful. A job description, if you have those, they are very helpful. The doctor needs to understand exactly what is being alleged. And if you do that, your doctor is going to be in a much superior position to the claimant's attending doctor, who, as all of you know, it's very rare that the attending physician has an accurate understanding of what the claimant really does. So this is information that makes your report inherently better than the attending physician's report. Maybe it goes without saying, but I think it's very important. You need to provide all of the relevant medical records. You need to make sure that the doctor is aware of past problems, records concerning past treatment, all those things. So you need to do your due diligence and send the records that you have obtained when you're doing the examination. I think it's always important to ask the doctor if he needs anything else, because oftentimes the doctors will review these letters before they've done their exam or during their exam, and they say, you know what, I really need that MRI that was done 2 years ago, or I need the EMG that was done. Those type of things are important. And some doctors will not take the initiative unless you ask them, say, hey, what else do you need? What can I do to make your life easier? And I think it's also very important to authorize diagnostic testing when necessary. Typically, I tell the doctors when I do the referral letter that please perform any diagnostic tests that you believe are reasonable, necessary, and appropriate. That's the language that I use. And I think that's important because if the doctor needs to take an x-ray, if the doctor needs to do other types of testing, sometimes blood testing is done and things along those lines, they need to have the authority to do that. Now, they may need to obtain releases from the claimant on some things if they're doing an invasive test, but most of the offices that do a lot of IMEs, they have those releases already prepared and they have them ready to go, and they do them. What about the questions you ask the doctor? And this goes back to shooting yourself in the foot. If you ask the wrong questions, you can get the wrong answers. So without being redundant, ask the correct questions. But what are those correct questions? Well, first and foremost, be specific. The worst question that you can ask, and I'll admit that I've asked it on occasion when I've had to, is what condition, if any, resulted from this alleged industrial injury? You're asking for big, big problems. You may be thinking you're asking the doctor about a lumbar strain. The next thing you know is you have a herniated disc, or you have a sprained ankle, or you have all kinds of things. Do not ask open-ended questions. You will get burned. As I said, I've done this myself. Sometimes when you don't know a lot about the claim or your records are sort of incomplete, you're stuck. But the first question should never be, what conditions, if any, resulted? That's just not a good way to write a referral letter. Use correct standards. And I'm going to come back to this in a moment, but we'll talk about the KRISE case criteria, which involves occupational disease claims. We'll talk about direct cause, substantial aggravation, and return to baseline. But you need to use the correct standards. You need to define what the terms are and what you're asking for, because if you don't, you can't assume the doctor will just know what the standards are. Now, a lot of the docs who do a lot of IMEs do know some of this, but a lot of others do not. And another one also is, has the condition resolved? And we'll talk about that in a moment, but these are things that you can ask the doctor in any question, in any letter. So I think when you have an exam, there are a couple things that are always going to be asked. You're going to ask a specific question that you want answered, but you're also going to ask, has the person reached max medical improvement, and what additional treatment, if any, is necessary? Because those things, to go back to one of the initial points, will give you a baseline that you can use for future problems. What's not essential? What are the non-essentials in these things? Well, please do not editorialize. No matter how much some claimants can be infuriating or have done things that are bad, if you write your letter in such a way that editorializes, it may come back to bite you. So you don't say, Joe the claimant is a lazy worker. The records may show he's a lazy worker, but you don't want to say it. The claimant is a liar. You can point out inconsistencies, but you do not want to make accusations. And the reason for that is your letter may become a record in the future in a court case, or the doctor may quote you. Now think about this, and I've seen this happen. You write something in a referral letter to a doctor, and as we've said before, that letter should not be part of the commission file. But what if the doctor decides to quote you that the employer's counsel or the employer or the third-party administrator says A, B, and C, and he puts it in his report? Well, if you do that, that's part of the record, and the focus of the hearing then can change based on what you have said. So you do not want to do that. Also, in a court case, oftentimes when the doctor's deposition is taken, they're going to look at all the records he had before, and they may try to put that referral letter into evidence. So you do not want to editorialize, because as I said, this could make you a witness or things that you don't want said out in the public. One way to avoid this problem, if you really think it's critical and there's something that's involves being lazy or lying or whatever it is, you can call the doctor. So call the doctor, talk to him directly, but do not put it into a letter that may eventually be discoverable or made part of the doctor's report. In fact, if you have the time and the ability, I think it's always good to talk to the doctor when you can and let him know what's going on. If something's not out of the ordinary, it's probably worth your time to call the doctor and say, doctor, were you aware of this, this, and this? The employer is concerned because of this. This is the background. The person was a point away from being discharged, and there's been a history in the past. They have a history of gaming the system, whatever it may be. So if you're going to do that, you need to talk to the doctor directly. Do not put that in a letter. There are other things, though, that you can always do. If there are credibility concerns, point them out, but do it in an antiseptic way. Inconsistent medical reports. Oftentimes, the attending physician may say one thing on a certain date and another thing on another date. And very importantly and very common are inconsistent descriptions of injury. I don't think there's any claim anymore where we just have one claim application. There seems like there's always 3 or 4. And when that happens, there are different discrepancies of injury or descriptions. The accident report may have a completely different description of injury than the claim application. Things like that should be pointed out and told to the doctor so he is aware of them. But once again, you do that in a do it in a way where the doctor knows the facts, but you're not going to be quoted on it at a later date. This goes also with attendance problems. If you have someone that has a problem coming to work, the doctor ought to be aware of that, because there also may be a medical reason why that person's not coming to work. Maybe the issue really isn't the person's back claim, but rather it's some other issue going on with this person. Also, prior relevant medical history and records, these should always be sent to the doctor, and it's something that just should be a given. Now, I will tell you that one of the practical concerns that all of you know if you do these types of things are that getting the records timely is often very hard. So what I would suggest, and what we do frequently here, is we will schedule the examination. If we don't have all the records, we will write a referral letter to the doctor and send them what we have and tell them we will supplement the records. You can then have them hold their report until you have the additional records, but the report is only as good as the records that you have sent them. So it's really critical that you do these timely and also get them the information they need. Caution. Words matter. And although a lot of our politicians may not understand that, in workers' compensation, we know that the words matter. There's a big difference between what's an exacerbation, an acceleration, an aggravation, and a substantial aggravation. As I said before, you need to define these terms, and the doctor needs to know what's going on. And if the attending physician has used these words, we need to point this out, because an exacerbation and acceleration does not equal a substantial aggravation. Okay, let's go through a few of these things that you may want to use in the letters to the doctors that are helpful. This is called the screen you have in front of you now is called the KRISE case criteria. And what this deals with are claims which involve an occupational disease. Now, it's sort of interesting how this has evolved in Ohio, but we have, as all of you know, 2 types of claims. We have occupational disease claims and we have injury claims. And we have separate statute of limitations for each, and we also have separate standards of proof. However, our claim application involves both. And what's happened is the lines have been blurred. If someone has a scheduled occupational disease like carpal tunnel syndrome, epicondylitis, some things along those lines, there's a specific standard that is applied for the claim to be found compensable. And this comes out of a case that was called the KRISE case. And also you'll find in the statute for occupational disease, these standards are in the actual language of the statute now. And it's written in terms that it took me a long time to figure out what it means, and I'm not sure that I actually do to this day. But essentially, it says you have to show, or the claimant has to do something that is peculiar to his specific employment. What makes it different than employment in general? What's different here? I mean, a lot of people perform repetitive work, but what's different with this person's job that makes it peculiar to this and would cause this type of condition? We get this also in sometimes stress cases, heart cases. Well, I think everybody would say their job at one point or another is stressful, but what makes this particularly stressful to this individual? And that is one of the standards for an occupational disease claim. And also, does the claimant's employment create a risk of contracting the disease in a different manner than the public in general? So what's unique about this person's job? We have a lot of people doing this job, but why does this person have a problem? And so these questions, there's actually the two questions here. I think when you have an occupational disease claim, you should ask these two questions. Now, the practical part of all this is when claims are pursued today, a lot of them are pursued both as an injury and occupational disease. If the claimant's doctor, and I'm going to bet you $100 to a donut, he won't, has not addressed the KRISE case criteria, your report is going to be superior. Substantial aggravation. You've all probably heard different speeches on substantial aggravation and know that that's been the law of Ohio now for about 10 years. Unfortunately, the Supreme Court has not ruled on a lot of things about it, but it is out there, and we've defined it, and you should define it for the doctor, because substantial aggravation is contained in the Ohio Revised Code. This section is noted on your screen. Defines everything in the negative, and basically it says an injury does not include a condition. It does not include a condition that pre-exists an injury unless that pre-existing condition was substantially aggravated. However, for substantial aggravation, you need objective evidence, diagnostic findings, clinical findings, objective test results. Subjective complaints by themselves are not sufficient, and it's critical that you tell the doctor what the standard is for substantial aggravation. Now, the people that do exams all the time know the definition, but I think it's important for them in their letter, if they can, to say they understand what the standard is, because a lot of the physicians don't. This especially is relevant if you're using physicians in an out-of-state exam, and they don't know what Ohio law is on substantial aggravation, so you need to define it. And I think as a matter of course, it's a good practice to always define substantial aggravation. Return to pre-injury status. This is another provision. If you have a claim that is allowed on a substantial aggravation basis and you're having the doctor do an exam on treatment or maximum medical improvement, you want to ask the doctor if the person has returned to his pre-injury status. Because if they have, there's a basis to shut the claim down completely. So this is a question you should always consider asking, especially in the context of substantial aggravation. Pay attention to the details. As the picture depicts, we're all different, and the worst thing you can do is have a male listed as a female, have race wrong, have age wrong, all these types of things, because if you do, the report does not have credibility. It's your responsibility to get the right information to the doctor, and it's also the doctor's responsibility to pay attention to detail and have it right in his reports. And we've all seen situations where they don't do that, or the referral of the information is inaccurate, and that creates issue. If you have the wrong knee listed, the right or the left, those type of things, you have a big problem. Prior testing. Detail is critical. Some conditions, let's talk about carpal tunnel, may not specify whether it's the right or the left. Is it bilateral? You need to make sure you ask the doctor is aware of which condition or which specific side is being requested. The medical records must say what you say they say. If you're giving the doctor the wrong information, we're going to have a big problem, and the doctor's going to have a problem. Conversely, the doctor better quote, the medical records right. And if they aren't doing that accurately or consistently, then find another doctor. Review the IME reports before they're filed. This is something that's very important and oftentimes is a problem because of the timing. But you need to review these reports and make sure certain things have been done. Is the opinion supported by the records? The last and the worst kind of report you can have is a report that is written that just says yes or no, but there's no records supporting it, there's no basis for the opinion. Before you send this report out, did it answer the questions you ask? And as I said, you do not want them to answer other questions. A problem we see in the psychological claims frequently is you'll ask a specific medical condition. Did the claimant's work activity cause major depressive single episode? And they'll say, no, it didn't cause that, but it caused these 3 other conditions. You don't want that. You want only the question answered that you ask. That's why you need to spend the time on the questions before you send them. I think another thing always to critically do when you evaluate your reports, is there an alternative explanation? Most of the claims that we have, the person have a problem. They have a bad back. They have carpal tunnel. They have the condition. But why do they have it? Is it because of their prior problems, their obesity, other risk factors that may exist? Your report is much more credible if your doctor has provided you with an explanation as to why this person has the condition. Because typically the question isn't whether they have the condition. More often than not, it's what caused the condition. And it's simple, but was the report signed? If the report's not signed, there are requirements that haven't been met and can cause a problem. Avoid inconsistencies. I've seen this a lot where the doctors will write the report and they'll have a summary and conclusion and they'll say, this condition isn't work related. And then in the answer to the questions, they'll say, it should be allowed for. Read these reports thoroughly, look for inconsistencies, because if you have those, you're going to have a problem. Doctor who do you use? Well, we have lots of kinds of experts in the area, and you need to look at what your condition is. The go-to physicians in this area today are docs, occupational physicians. They seem to be able to cross most lines, and they're more docs doing IMEs than anything else. If you have a true orthopedic problem, an orthopedic surgeon is preferable. And then also we have neurologists if you have head injuries, those type of things. There's always a debate on whether you want to use a psychologist or a psychiatrist. Remember, if you are dealing with medications as an issue, then the psychiatrist is the one that's qualified to give the opinion on that because they can prescribe medication. Chiropractic, oftentimes if the issue is chiropractic, I think you have a little more credibility if you respond with a chiropractor, someone of the same discipline, because as a lot of you know, medical physicians and chiropractors don't always see the world in the same way. Certified nurse case practitioners. I put this up here simply to point out that they are not qualified at this stage or accepted to give independent medical reports or an IME. That may change. Their role has been expanded greatly, but as of now, you can't have an IME with a certified nurse case practitioner. You also need to know your doctor. What's the doctor's view on aggravation? Will he or she testify in court? Because a lot of doctors won't do it. They don't like cross-examination. And are they credible in the administrative agency? Those of you who are in the agency know that some doctors' reputation is not real wonderful. Others are. Also, make sure that their license is valid and they haven't been accused of a lot of misdeeds over the years, because I've had that on the other end of this where someone will come in and say, well, you know, they lost their license. There's a Toledo physician, for example, that's doing a lot of claimants IMEs on permanent partial that does not have a license to prescribe drugs because he was a drug pusher. So these are things to know because you can use them to your advantage on occasion. Let's look at a couple of situations quickly, as I know we're getting short on time. Although my picture isn't a female, I think it's a good picture. You have a 36-year-old female who's an office worker. The person has diabetes. They're heavy. And they do some time typing, but their primary responsibility is to answer the phone. What type of doctor? Who should you use in this type of case? Well, if this is a carpal tunnel case, I would suggest the best type of doctor is to use an occupational physician. Why? Occupational physicians are specifically trained to deal with the cause of a problem. They also can look at the ergonomics of the problem. That's what their specialty is. That doesn't mean they're the only ones, but my experience has been they're the best qualified in these type of cases. Let's look at another one. I actually have a case where this guy was a 45-year-old male cemetery worker. He dug graves. He had a history of back surgery. He was heavy. There was no specific incident. Had recent chiropractic care, and now has leg pain, and MRI shows that he had recurrent disc at the same level as his prior surgery. Who's your choice on this one? Well, in this case, I would suggest an orthopedic surgeon, if you have one. Now, there's one caveat to this, and that is, if you know your doctors and you need to know who the applicant pool is here for doing the exams, some doctors will find a substantial aggravation if there has been a pre-existing surgery. We have a couple orthopods in town. That's what their view of the world is. So guess what? That's probably not who you want to choose for your examination. But I think overall, if you have an orthopedic a question like this, an orthopedic surgeon is probably your best bet. So I think that's about what I have prepared for today. If you have any specific questions, I'll try to answer them if you type them into the screen here. I appreciate everyone attending today. I hope it's been helpful. And you can also, if you have any specific questions before we conclude today, you can send me an email at rsolt@bugbeelawyers.com, and I'll be glad to answer your questions. Thanks again. I hope everyone has a good rest of the week. And just remember, when you do your IMEs, you need to be prepared. And if you are prepared, you'll get the answers that you need, and you'll also be able to do your due diligence, because what we're all looking for here is a truthful answer. We want to know if it's a good claim or a bad claim. If it's a bad claim, you fight. If it's a good claim, you pay the claim and get on with life. Thank you very much, and I hope everyone has a great day.